So our topic for this month's rights training is rights in the HCBS final settings rule. Um, there we go. Um, the topics we're going to cover today are the HCBS final settings rule itself, the background and intent of the final settings rule, um, and the 10 federal requirements, or the 10 pieces of the final settings rule. And then with those, we're going to go over some exploratory questions that CMS has given, because when we have regulation, whether it's state or federal, it has to govern a lot of stuff, and you can't make regulation too specific because regulation is really hard to change once it's written. So you don't want to be too specific and have the regulation end up being applied in ways that you don't mean it to. And so regulation is usually written with fairly broad language, and then CMS will put out guidelines and FAQs, things like that, to help us understand their intent and what compliance with those regulations looks like. And so as part of that, they gave us some exploratory questions to ask to get at what compliance looks like. And so we'll go over some of those for each of the 10 requirements, and then some examples of non-compliance that you might see out in the world. And then we're also going to talk about modifications of those 10 requirements and how that is allowed. Then we're going to talk about how this interacts with our state law and division policies around participant rights, and what we do if we see an issue with compliance with the final settings rule. And the reason we're talking about this in terms of rights is because the final settings rule, you'll find that a lot of it fits in with or kind of dovetails with some of our policies around participant rights. And so, sometimes the HCBS final settings rule is an additional element of rules that we need to make sure are followed around participant rights and making sure our participants have the lives that they want. And so it's just a kind of another piece of the puzzle as far as our participant rights go. So the history of the final settings rule, it was a federal it's a federal set of federal regulation. And at the end of the slideshow, I have resources that you all can access if you like to. And one of those things that is linked in that resources page is the actual citation, and you can click on it and go to the text of the actual federal regulation if you'd like, or if you would like to reference somebody else to it as part of conversations you may be having. But it's federal regulation. It was promulgated by CMS in 2014. And then there was a 9-year transition period. I think it was actually originally supposed to have a 5-year period to transition into compliance, and then that was extended. And so states during that 9-year period had to make a state transition plan that had to be submitted to and approved by CMS about how states were going to bring their home community-based services settings into compliance. And then the rule or the regulation went into full effect in March of 2023. So it's been about a year and a half since the final settings rule fully went into effect. So before we get too far into this, I want to touch on the applicability of the final settings rule, because sometimes folks get confused. I just got an email the other day about a setting, a sober living facility where a person was getting services and the person doesn't have a lease. And somebody was saying, well, I don't know if we can serve them there. And I'm like, whoa. The final settings rule applies to provider operated settings. So settings where intermittent services like independent living or supported family living, or in that situation, it was on the AD side. So it was personal care services. These rules aren't applicable to those settings. Now, all of the other divisions rules around participant rights and restrictions apply anytime waiver services are being delivered in a public place, in a participant's own private home, in a private family home. Our policies all still apply, but the final settings rule is specific to provider operated, owned, operated, leased, or controlled settings. So on the DD side, that is group homes, shared living homes, host homes, and day sites that are operated by DD providers. Any questions about any of that? So CMS's intent with the final settings rule, there were three aspects of it. The first was to enhance quality of services in person-centered planning. The second is to add protections for participants in waiver services. And the third is to ensure that participants are integrated in their communities and that settings do not have institutional features. And what brought about the final settings rule was that CMS was going out to states and visiting service settings because there was a big push, over a number of years to move away from folks with developmental disabilities really only living in institutional settings, so nursing homes, ICFDDs, and that type of thing. And so there was a big push over a number of decades to get people living in their homes and communities. And so a lot of states were very successful at that. And we got a lot of folks that had been living in institutional settings out and living in their homes and communities, which is wonderful. The issue that CMS found is that we really only changed folks' geography. And instead of folks living all together in one big state operated institution like BSDC, we created dozens or hundreds of tiny little institutions that weren't really operating very differently from a place like BSDC, as far as really being truly integrated in the community and preserving participant rights and, all of those things. We had created, dozens or hundreds of institutions all over our state instead of just having a place like BSDC. And so that is kind of what brought about the final settings rule was that, if we're going to have home and community-based services and say it's better for folks to be living in their homes and communities, then they really need to be living in their homes and communities. They need to be part of their communities like any of us are. And that really isn't what they were seeing. And so they came up with these 10 requirements of home and community-based services settings to ensure that they were not being operated like dozens of tiny institutions all over the state. Because if any of you have been around long enough that you remember all of the lovely inspirational talks that we had with Dr. Tom Pomerantz when the state used to contract with him years ago. One of his famous catchphrases was, "An institution isn't a place, it's a state of mind." And if we're still treating somebody like they live in a nursing home or an ICF, then all we've really changed is their physical geography. We haven't really substantially or meaningfully made their life better. So, any questions about any of that background? Okay. So these are the 10 federal requirements. I'm not going to read them to you. I mean, I am, but I'm going to do it one at a time over the next several slides. But I wanted to have them all together here on a slide as just a reference for everybody to have. So we'll get into each one on an individual level and kind of talk about what each rule is and what it means. So the first one is community integration, rule number 1. So the setting is integrated in and supports full access to the greater community, including opportunities to seek employment, engage in community life, control personal resources, and receive services in the community to the same degree of access as people not in Medicaid services. So on each of these slides, the rule itself is going to be in this blue kind of bubble up on the top left corner. Right below it are going to be some of the exploratory questions that CMS has given us that really, I think, help us get a picture of what compliance with this rule looks like. And then on the right side, we have examples of non-compliant of situations that might be non-compliant with this part of the final settings rule that you may encounter, that we want folks to be able to not just understand like, yeah, there are 10 rules and kind of loosely what they mean, but really to be able to identify some of these problematic things when we see them. So some of the exploratory questions for community integration include, does the participant engaged in scheduled and unscheduled, and I should like underline and highlight the unscheduled part of that question, activities in their community? Because I don't know about you, but I do have some scheduled community activities. Nobody in my life calls them outings except me, if I'm being ironic because I work in this field, but nobody calls them outings. I go places and I do things, not very much because I don't like to go places and do things, but I also do things unscheduled. Sometimes I get a wild hair to go get my nails done or go to Target, and I don't have to like schedule that 3 days in advance or something like that. And we know practically, like with staffing and things like that, there are natural limitations, but that we kind of have to work with. But we shouldn't be creating expectations that a person can only engage in and integrate with their community in ways that are scheduled in advance or ahead of time or chosen from a menu of pre-scheduled or pre-arranged activities all the time. Does the participant come and go from their home or, you know, another services setting as they choose? Does the setting provide opportunities for a variety of age-appropriate and meaningful activities? Is the setting located amongst other residences or businesses to facilitate integration? I don't know if it's still open. I, I hope it's not. But when I used to work for CSN many moons ago, I was a DSP in a group home back when I was in college, but I used to cover shifts at the day site sometimes over the summer. And they had a day site that was like this industrial building with big garage bays. And it was out in the middle of kind of an industrial area where like there weren't other businesses, wasn't foot traffic, there wasn't, other people around. Like that is a setting that we could potentially say has the effect or maybe even the intent of isolating participants from the broader community and not integrating them into it. So that's an example or one of the exploratory questions we have. Does the setting have information available about opportunities for employment, volunteering, and recreational activities and support participants to access them as they choose? And does the participant have access to their personal funds to spend as they wish? Those are all exploratory questions that we have from CMS. So examples of non-compliance with this one could include, like I mentioned, the participant has to schedule ahead of time if they want to go to the store or a library. The day site doesn't have many options for activities that are consistent with people's preferences. I know that a lot of assisted living facilities that we looked at under heightened scrutiny had to ensure that they were complying with this part of the rule, they would survey their residents and say, what kind of activities do you want us to have, to make sure that they were offering things that were relevant and not just offering things that people might participate in, but they don't really care about, that are sort of like life wasting. Activities, Director Green likes to talk about the famous van rides. And if that's something that your participants particularly like to do, there are some people that do. My mother-in-law and my husband's aunt love to just drive around. And if that's something that makes them happy, cool, cool, cool. But if that's the only thing that they have access to and it's something to do just to do, that's not really what we're looking for when we talk about what CMS wants HCBS settings to look like. Participants in a group home rarely leave the house unless they can all agree on a group activity. The participant says they're interested in seeking employment and the provider doesn't facilitate them in accessing resources through you and their team and VR. That would be concerning. Anytime a participant expresses that desire, they should at least be informing them of what resources they can use to access that and, helping them connect with those types of things. Activities are available only include like children's puzzles and coloring books and G-rated movies. I know you all probably know of some sites where one of the weekly activities that's offered is everybody gets to go to the movie, but there isn't really a choice of movie. Everybody goes to the same one, and it's almost always whatever children or family movie is showing and not a movie that like most groups of adults would choose to go to together. The participant, or another example is the participant can only access their money by going to the provider's business offices on weekdays during business hours. I think that maybe happened maybe in Nebraska City, where a participant's checkbook was kept in the office at the day site. And so they could only get to their checkbook when, like during business hours, Monday through Friday. That's something that really explicitly would not be in compliance with the final settings rule. So any questions about this one before we move on? Okay.
It's a quiet group today, Sarah. Everyone has candy on the brain.
Yeah, or here in Lincoln, anybody here in our office here, they can smell the soup for Chilloween. I made 4 dozen cupcakes. They're sitting here behind me. I need to send Shauna and IM to go put them out for me. All right. Next one is choice of settings. The setting is selected by the participant or the individual from amongst setting options, including non-disability specific settings. The settings options are identified and documented in the person-centered plan and are based on the individual's needs, preferences, and resources. So in our state, this is really something that more falls on us because we're the ones talking with participants about choice of services and services settings. And so we should always be talking with them about all of their different options, including non-disability specific settings like services like community integration or supportive family living that can, happen in their homes or out in the broader community. So some exploratory questions: was the participant given a choice of available options for where to live and receive services? Was the participant given an opportunity to tour other settings? Does the setting reflect the participant's needs and preferences? Do the options offered include services delivered in a non-disability setting? So like I said, some of that is more our responsibility since we're the ones who do service coordination in Nebraska. But some examples, but providers as the members of the team also kind of have a role in this. And so some examples of non-compliance could be when reviewing service options, only those in provider operated settings are explained. If the participant expressed an interest in a variety of providers, but were encouraged to choose one without maybe visiting other options, or if the participant expresses that they don't like going to the hub and options to provide the service entirely in integrated community settings wasn't discussed or explored, that's something that those are things that if they happened could be considered non-compliant with the final settings rule.
And
The
what,
next one,
Sarah,
go ahead.
I was just going to ask, I mean, what, and I know this happens a lot. I mean, what if we come across a guardian or parent that says, all right, we see one provider, yep, we like that one, and they really don't care what the participant's opinion of it is.
Yeah, and that's tough because that really isn't how guardianship is supposed to go. Like, guardianship is intended to help them make choices in their best interest to help them live the life that they would want to live, not to impose your own preferences and values, etc., on your ward. However, you know, guardians do have decision-making authority and unilateral decision-making authority over where a participant resides. And typically for arranging their benefits, those are things that are spelled out um, in the statute that governs guardianship. I would say though that if the participant is expressing explicitly, like, I don't like this day site, or sometimes they're not saying it explicitly, but they're refusing to go to day services like half the time. I think sometimes that gets labeled as a behavior, which is really unfortunate. And it's like, well, some people really like the hubs and the day sites and the activities that they offer there and seeing their friends there. I wouldn't want to, that isn't how I would choose to spend my day. And that's not a life that I would necessarily want for myself. And so it's unfortunate to me that we see that sort of written off or labeled as a behavior in our participants. So I think in those situations, you just have to continue to present options, document that you're presenting options, and to, plant seeds and advocate to the greatest extent that you can.
Yes, Sarah, and if I could just offer it, actually answered it beautifully as always. I think, it's a tough spot for service coordination to be in because we know that we have guardians who will, be very particular or want it to be the way or the setting that they want. And I think all we can do is provide those options, like Sarah said, so people can make an informed decision. If you're in a position where the guardian doesn't want to look at other options, not only document it, but I think it's okay for service coordination to say, hey, this was the first site we looked at. I know that there's a couple of other places we can explore. Do you think it would be good? Like, I think you can try one more time. I don't want us to harass people. I mean, ultimately, if they've made their mind up, they've made their mind up. But as long as you've tried that one more time to say, I talked with the other two providers. They seem to have good options as well. I think that's all we can do. And Jennifer had put a comment in here too about, and I think this happens a lot, where guardians will ask service coordination to not disclose to a participant about moving from one SLP to another, moving from a group home to an SLP. And again, that puts you guys in a really tough position. Ultimately, it's the guardian's choice, but it is our job to advocate, and it is our job to communicate back to say, hey, I understand based on, some behaviors that they might display or their emotional state at this time, you don't want us to, but, trying to work with them and partner with them on a way to still make sure that the person is feeling like they're a part of the decision. They're able to help make the decision with them. So maybe you agree that you don't tell them 3 weeks before, but you tell them the day before, or prior to them going to work that day, because I do think this comes up, but ultimately the guardian reserves the right to make the decision, and it's our job to make sure they understand what might be best for the situation and for the entire team making an informed decision. I don't know, Sarah, if you have anything additional to add to Jennifer's comment, but as I
Yeah,
was
with
answering that,
that
I saw it come
piece,
in.
ultimately the guardian chooses the participant's residence, but I don't know that they necessarily have the authority to demand that we withhold information from the participant. Now, I think that that is a situation to handle delicately, and to have the team discuss, because there are folks that it would truly be counterproductive, sometimes maybe even lead to unsafe conditions. And things like that have to be handled really carefully. Um, but, and so in those situations, discussing as a team, discussing with a behavioral professional or a mental health professional, if there is one that works with that participant and team, about how to best approach it to help the participant understand and adjust the change as best possible, would be really important. And also talking with, if it isn't a matter of, we're concerned the participant may run away and we wouldn't be able to find them, or we're afraid that they would behaviorally unsafely. If it's just a matter of the guardian, thinking that they might be a little anxious or, things like that, then really, still very, professionally and respectfully, but discussing with them, this is their life, this is their services, just as any of us would not appreciate somebody making these choices for us without even us having an opportunity to express our opinion or to know about it in advance to adjust to the idea. That wouldn't feel good for any of us. And so that's really something that we try not to do. And, you know, because guardians aren't, loved ones of people with disabilities aren't exempt from the socialization that we all kind of have that tends to sometimes infantilize folks with disabilities. And so, working in our field or having a child with a disability doesn't erase all of that that we experience throughout our lives. And so sometimes it's our role to advocate and maybe help them understand why we try not to do things like that. Because it may be aspects that they haven't maybe considered because they're still thinking of the participant as their child as they thought of them as a minor child and not as their adult child.
Hey, Sarah, one quick question on the choice of settings. So
Mhm.
I know that you've mentioned like guardians not allowing specific providers or choosing specific providers without like the participant's choice. So what would it also be a non-compliance if you have a participant who wants to go to an SLP? Family states they want her to go to an SLP, but then they put so many like I don't know what you would call them, restrictions. I it's not the right word, but like they're demanding like a list of things that's eliminating all of the SLP options. Like they've went through 50 plus SLP options, but they're like they have to be the only participant. There can't be any kids. It has to be a single person who's not married. It has to be a ranch style home. It has to be in a specific part of town. Like
Mhm.
just like they took the pool and now there's nothing available and it's to the entire region. Like does that consider non-compliance or is that just
So the compliance with this is really about offering options, educating on options. But like I said, ultimately, if a participant has a guardian, that guardian chooses their residence and can kind of decide what that looks like. Um, and so that's, again, I think a situation where we educate and we advocate and we plant seeds to try to, because sometimes you're not going to change somebody's mind in a conversation. I mean, it does happen on occasion, but a lot of times, sometimes you just have to put things out there and let them kind of marinate and come back to them next time you go out for a service review or next time you have a team meeting. Um, and yeah, barriers, that's something I talk about a lot because of a lot of everybody. I see everybody do it in our system. You're talking about one of the options and they say, well, we can't do it because of this. And they intend that to be the end of the conversation. There is a barrier, so we can't do this thing. We might as well stop discussing it. That's never how we should treat barriers. The barrier being brought up is great because when we're thinking about making changes, we want to know about those things ahead of time so we can plan around them. But that should never be the end of a conversation. It should be the beginning of a new conversation of, okay, there is a barrier to this. What can we do? Are there creative ways that we could work around this? Are there non-traditional ways that we could meet this need or provide this service or whatever that are still within all of the rules, but would better meet the needs and preferences of this person and their family, things like that. And so yeah, I think that that's, if it's a barrier that, all the homes have pets and so is has behaved unsafely around pets before. Maybe we have I don't know, this maybe isn't a good example, but like, give them opportunities under controlled conditions to get used to being around animals, maybe where they don't have contact with them initially, but they like, you know, they always refuse to go to the doctor's office. And so I had folks that I've worked with who have programs to help them desensitize to just going to a doctor's office or a dentist's office. You know, those are conversations to have is, you know, okay, so this is a problem. Why is it a problem? And what could we do instead? Or what could we do about it? And yeah, advocating, planting seeds, educating. That's really sometimes as far as the choice of services and residents as much as we can do. But it's important that we do it because we know that there are families that aren't always open to all of the options or what would be best or promote the greatest independence for their loved ones. And that's what we want for them ultimately, is to get everybody feeling good about those options and, you know, potentially moving in that direction. Number 3, the setting ensures the individual's rights of privacy, dignity and respect, and freedom from coercion and restraint. So some of the probing or exploratory questions here. Is there a readily accessible complaint process, and is information about how to make a complaint available to participants? Is private information kept private and discussed discreetly? Are participants groomed as they prefer and dressed in age appropriate and seasonally appropriate clothing of their preference? Do staff talk about participants as if they aren't there when they are? Do staff address participants as they prefer? And are restrictions only used with informed consent and in accordance with division policy? So some examples of non-compliance with this aspect of the final rule might include when staff discuss a participant's medical diagnoses or treatments or their schedule of bowel movements just out in the open in a public place where people can hear. That is not respectful of the rights of privacy or the human dignity of our participants. It is not a way that we would appreciate anybody talking about any one of us in a public place or with strangers or where strangers might overhear. If the provider doesn't have a complaint process or that complaint process isn't accessible, I came across a provider who, it was somewhere in their PMP, they said that a complaint would only be accepted in writing. And I'm just like, no, no. That doesn't work. If staff called all of the participants honey or sweetie rather than their names or how they prefer to be addressed. And I know that there are some people that just kind of do that with literally everyone they encounter. And so, you know, reminding them that it's important to address people how they want to be addressed. And some participants don't care, some might. But sometimes that happens in ways that is kind of, I'll use the word again, infantilizing to our participants. And that's really not okay. So staff use rights restrictions without team guardian or HLRC approval. That's going to be not only a violation of all of our division policies, but a violation of this aspect of the final settings rule as well. Staff habitually talk about participants and not with them. That is something that is so common, and not just, you know, staff, not like medical providers. I don't know if any of you guys know Joni Thomas. She works a lot in the disabilities advocacy community. She lives here in Lincoln, and I went to a training that she was one of the presenters for Disability Rights Nebraska, and she talked about how, and she has a physical disability, but she does not have any intellectual or developmental disability. She doesn't have a guardian, but she needs help getting around. And so when she goes to the doctor, she has somebody go with her to help her. And her doctors will talk to the person who just drove her there and not to her about her own health care. Those are the types of things that we're talking about here. Now, we can't control medical providers, but this would be applicable to what's happening in our HCBS services with our service providers in those provider controlled settings that we wouldn't want to see. If a participant needed support with nail care, but their nails are frequently long or ragged or dirty, participants in a group home sit around in their PJs all day on weekends, even if that's not their preference. And I talk a lot about preference in some of these because if it is a participant's preference to use children's coloring books or to always be in PJs when they're not out in the world, that's my preference. And, you know, so if that's the person's preference, that's fine. But what we're talking about here is where they're not, you know, nobody is getting helped to get up and get around for the day because, you know, why put in the effort because we're not, you know, being respectful of their human dignity and their preferences. That's the kind of thing that we're talking about here as far as supporting the participant to, you know, be up and ready for the day, to be neatly groomed in accordance with their preferences and those types of things. Or if the participant is frequently dressed in stained and ill-fitting clothes. Now, if that happens to be their preference, I think we would then maybe encourage them to explore different options in clothing. But, you know, if the participant needs support with dressing and choosing clothing and they're not being supported to maintain a dignified appearance because just don't care, like that's where we're getting into problems with this type of thing. Any questions about this? The setting optimizes but does not regiment individual initiative, autonomy, and independence in making life choices, including but not limited to daily activities, physical environment, and with whom to interact. So exploratory questions here. Are there locked doors or other barriers preventing participants from accessing common and shared spaces or with interacting with different groups of people? So going back to that day site that I had pulled some shifts at back in the day that I hope isn't still open, each participant was assigned to a bay in this like kind of industrial building, and they were sort of sorted by like their level of independence or disability, and weren't allowed to like go between bays or interact with people in other bays. And it was just kind of, no, this was back in 2007. This was pre-final settings rule. Things like that are the reason why this rule exists. That's why I say I hope it's not happening now, but that's an example of if we did see that happening, it would potentially be non-compliant. Are there a variety of groups and individual activities offered to support participants with varying interests and needs? Can participants engage in legal activities for their age, such as smoking or vaping, drinking alcohol, if it's appropriate? Like most people going out to public places or to the Y or to their job aren't drinking alcohol there. So not having alcohol at a day site probably makes sense. But like a lot of us have alcoholic beverages in our home. We might go home and have a glass of wine or a beer after work. And if our participants wanted to do that and that's being limited, that could be problematic from not only a rights perspective under our policies, but from the final settings rule. And can participants eat meals when they choose and with others or by themselves? So examples of non-compliance, I kind of alluded to this one, doors between different areas or groups in the day site, and participants aren't allowed to move between them if they want or interact with other groups. If all activities offered are group in nature and there aren't activities or support for those who want more solitary activities, participants served in the setting aren't allowed to smoke, vape, drink alcohol, etc. if they wanted, and it was, you know, made sense for that type of setting. It's a setting where any of us might engage in that type of activity as adults. If the break room at a day site was kept locked so participants couldn't get in there to access their food and drink or vending machines or their own possessions without staff support, or if a participant was told they couldn't engage in an activity if others in that setting aren't interested in also engaging in that activity. Those would be some examples of non-compliance with this aspect of the rule. So Kyle asked, how does this work when there are participants in a group home and one of them has a restriction to the kitchen or sharps and it affects everyone in the house? So we're going to get into modifications here when we get through all of the rules, but that would be a modification of the final settings rule. And part of the regulation, the federal regulation, lays out how modifications of any of these can happen, when they're allowable, what that entails. Next, choice of services and supports. Oops. Angela asks, for psychotropic medications and drinking, if a script is provided by the PCP or psychiatrist limiting alcohol intake. Yes, it would still be restrictive because, you know, we all have the choice to follow or not follow our doctor's recommendations, and our participants have that same right. And so, yeah, like, regardless of the justification, these are the rules. And if we're going to modify them, then, you know, even for a really good reason, then we have to do that under, you know, we have to do it correctly and in a way that is allowable, both under the final settings rule and with our own division policies. Adding to Kyle's question, what about if your participants in a group home and has met their reduction, but other members of the group home still require that restriction in place? Yeah, no, I can touch on that. But essentially, you know, if two people in a group home need the same restriction, then it's a restriction in both of those plans. If one of them stops needing it, then it basically becomes a situation like if one participant needed the restriction and the other one didn't in the first place. We would, and there's some specific guidelines about how to do this and how to document this in the restrictions SOP. So I would recommend you take a look there, but we have to do some things to try to minimize the impact. We document it in a really particular way and those types of things. A lease or residency agreement. So the setting provides for a legally enforceable agreement between the provider and the consumer that allows the consumer to own, rent, or occupy the residence and provides protection against eviction. So on the DD side of things, this is only applicable residentially, obviously. Oh, did I skip over it? Oh, I did. I flipped to it and then I went back to add a question. Thank you very much. Choice of services and supports. So this one again is kind of falls under our responsibility as well. But the providers also as part of the team. So the setting facilitates individual choice regarding services and supports, including who provides them. So does the individual know who to talk to if they want to request a change in their service providers? Would the provider support the participant to talk to their SC or team if they expressed a desire to consider other provider options? Does the participant express satisfaction with their service provider and supports? Does the setting ensure participants are supported to express their preferences and to exercise autonomy to the greatest extent possible? Is the participant actively involved in the planning of their services and supports? So some examples of non-compliance could be if the participant stated they're curious about what other options there may be, but their current provider discourages them from discussing it with their SC and team. If the participant shared their preferences for their supports and activities with their team and these preferences are in their plan, but the provider doesn't honor these preferences in the provision of the person's services. Or if the provider consistently doesn't make an effort to support and engage the participant in their meetings. And I know that there are some people who just don't want to be in meetings. Samesies, I get it. And for some folks, it's maybe not safe always for them to be in their meetings. And so there are those circumstances, but for the most part, we should, again, always be doing our best to support our participants to be a part of every conversation about their lives. And if there are barriers, that should never be the end of the conversation. That should be the beginning of a conversation of what can we do?
And it would be always appropriate to say, have them join for the beginning or for the end or for part of the discussion. I get to Sarah's point, if the whole conversation or parts of the conversation seem to be a bit much for the person, that, you know, understandable. We want to be supportive of the decision, but there's no reason why somebody shouldn't help kick off their meeting and talk about the celebrations and talk about some other things. And then maybe they go back to work or go off to doing what they're doing. And I would really challenge you as a service coordinator to really encourage family members who are like, nope, they don't need to be here, to say, hey, it would be good for them to be here for part of it. And so would you prefer them to be here at the beginning or prefer them to be at the end? So it still gives some choice, but when in doubt, if they can't make it, then making sure that you're documenting that information on the ISP as well.
Yeah, and
I
be
think
creative.
I think we do really
Go
well
ahead.
with this. Sorry, Sarah,
No, you're
with
fine.
adults. I think as we navigate this new world with kiddos, it gets a little harder because sometimes parents want the meetings to be during school. So I don't know if you have suggestions or just to kind of put this on the radar, just because they're a kiddo doesn't mean that they need to be any less part of that conversation, parts of those conversations.
I would
Yeah,
I would
go ahead, Sarah.
agree, and I think that yeah, really advocating for folks and scheduling in times and places where they can be there, where they'll be comfortable, even if it isn't the most convenient for us or for their guardian or for or their parents if we're talking about kids or the providers. Because this is, and really underscoring for folks, this is their lives. We should at least give them a chance to be a part of the conversation. Because, I think we all remember times as kids where maybe our parents made decisions without talking to us. And that, even though you're a kid, that still feels really frustrating to not feel like you have any autonomy in your life or the amount of autonomy that is age appropriate for you to exercise.
And I
Kids have
think
different rights than adults, but they don't have no rights. And so
right.
really making sure that we're advocating there to the best of our abilities.
Yeah, and I think, Stacy, you bring up a really good point. This is going to be a larger issue as we're starting to serve younger and younger folks. And to be honest, I can appreciate where a parent's mind might be to try to hold one of these meetings while the kiddo's at school. And while, they're able to step away from work, it's harder to maintain some of this extra stuff during outside of your normal hours, right? When you're running around all of your kids to activities and family things. And so I think in those cases, when we're doing that individual family meeting, that's a really good time because that participant should be there, that you should be there during that time. And if we know the meeting will take place during school that following month or whenever that's being held, being able to say, hey, I know you're going to be in school. I'm really sorry I'm going to miss you. Here's some of the things we're going to talk about. Do you have something really important to you want me to bring up during that time? I mean, I think always encouraging them to be a part of it, but I do understand and I want to be sympathetic to families who are going to, especially as we're serving younger and younger youth with the family supports waiver. It's okay, but then we have to be creative how we can still get in front of the person and making sure that we're acknowledging to them, we know you won't be there. We're really going to miss you. Or if we don't have that conversation then post, right? Being able to try to go to their house that following week or whatever to be able to have the conversation to say, we missed you. Here's what we discussed. Anything to add? Great, breaking it down for them to what would make the most sense for them. So I appreciate you bringing that up and thanks for the discussion.
Sarah said, I remember shadowing and a provider had asked participant to leave the room because we were about to talk about finances and their argument was the participant can get upset. If we're talking upset, like, punching out a window or punching somebody in the face, maybe it makes sense. But then we need to talk about how can we support them to manage their emotions better during difficult conversations. And that should be something that we're hopefully having behavior supports around. But if it's just that they might not like it, there's all kinds of things that I have to talk about in my life that aren't my favorite topic, right? That's part of being an adult. That's part of being a human. Um, and that is kind of another thing that we do that kind of infantilizes our participants. You're treating them like children and trying to protect them from experiencing any kind of, unpleasant emotion. It doesn't serve them. It doesn't help them build anything towards meaningful independence as adults. And so, you know, really advocating for them to be a part of all conversations that are about their own life. And if they have difficult emotions about it, then doing what we can to help them manage and work through those. Okay. Next, lease or residency agreement. So the setting provides for a legally enforceable, and I probably should have put that in italics, agreement between the provider and consumer that allows the consumer to own, rent, or occupy the residence and provides protection against eviction. And that protection from eviction has to be equal to or greater than what is in your state or the jurisdiction's landlord-tenant laws. So does the participant have a lease, or for settings where the landlord-tenant laws don't apply, a residency agreement? Most participants on the DD side are going to have a lease. Where we see residency agreements are in settings like assisted livings, where the state's landlord-tenant laws don't apply. And that's more on the AD side. Most of our, I believe, all of our participants in group home, shared living, host home settings should have a lease. Does the participant know their housing rights and that they could, and when they could be required to move, like how much notice they would have to be given and things like that? Does the written agreement provide protections to address eviction processes and appeals that are comparable to local landlord-tenant laws? And this is an area that I don't know a ton about. I've actually had to do some research and educate myself on it in relation to a few things. But I have linked at the end of this a resource from Nebraska, Legal Aid of Nebraska, that goes over and explains landlord-tenant laws in Nebraska. So if you have, and it has, you know, information about when you should contact a lawyer and different things like that. It's a resource that's out there public that you can share with participants if you think that they're encountering a situation where a provider as their landlord is not being respectful of their rights or they're being treated unfairly. And then does the lease agreement contain provisions that are legally enforceable and not in conflict with other applicable law, regulation, or policy? So something that the final settings rule is clear on is that a lease or a residency agreement can't contain non-enforceable clauses, because a person, a landlord for any of us, can't just throw anything they want into a lease. And because you signed it to have housing, you're just giving up all of your rights. In fact, most state landlord tenant laws say that landlords can't put certain things in their leases, like a lot of landlords will try to put clauses in there that say, you can't sue us if you're injured, even if it's due to our negligence in this property. That is a non-legally enforceable clause. But landlords will still put them in there because if the person doesn't know that it's not legally enforceable, they might choose not to sue when they would have every right to do so. And just because they've signed that lease doesn't mean that they've actually given up their right to sue, because that is a non-legally enforceable clause in a lease. So for our participants, that also doesn't mean that a provider can put clauses in a lease that circumvent state law or division policy or regulation or the final settings rule. So a participant, a provider can't put in a lease that the participant has to pay restitution for anything they damage, and that just makes it so. Even if the participant or their guardian signs it, we have policies around that, around when restitution can and can't be implemented on our participants. And further, if any of us had a lease and we signed, like, I take responsibility for any damage to the leased property, and then I damage it and I move out and the landlord sends me a bill, I get that bill and I can pay it because I signed a lease that said I would take responsibility. Or I can be like, I don't really think I made those damages, I'm not going to pay it. And my landlord can't just take that lease and go into my bank and say, give me this amount of money out of Sarah Heinrichs' account because she signed this lease saying that she'd take responsibility for damages and then she damaged my property. They would have to sue me or have me cited legally or like criminally for property damage, and then restitution might happen out of that criminal proceeding as a penalty, right? But, you know, even when things like that are in leases, it doesn't circumvent my rights to due process, and it doesn't do that for our participants either. So things like blanketed restrictions, that's something that we're having some conversations about here at central office, some things that we're aware of, but you know, a provider can't just write something into a lease and have it circumvent all our policies around participant rights and rights restrictions, and can't also circumvent the final settings rule. That's not legally enforceable or allowable. So some examples of non-compliance is if there were no lease agreement in place in a residential setting, a provider-controlled residential setting. If the lease agreement didn't contain protections from eviction and appeal rights consistent with state landlord-tenant laws. If the lease states the participant waives their right to appeal an eviction, that is not allowed under Nebraska landlord-tenant laws. Or if the lease stated that, for example, visitors aren't allowed unless they're approved by the landlord. That is not legally enforceable. That is in violation of the final settings rule, amongst other things. And so they can't use a lease to circumvent other laws, regs, requirements. Privacy, roommate choice, and decor and furnishings. So the setting provides for privacy in units, including lockable doors, choice of roommates and housemates, and freedom to furnish and decorate the sleeping or living units within the lease or other agreement. So can the participant close and lock their bedroom and bathroom doors? Do other people knock before entering private spaces? So if a participant is relaxing in their room, do staff knock and not just barge right in? Are the keys to the home only given to those who need to have access to them? Is furniture arranged as the people who live there prefer? Are cameras present in areas with an expectation of privacy? Do the furniture and household items reflect the participants' personal choices? And do participants have private rooms or share a room only if they choose to and with whom they choose? So some examples of non-compliance. So if a person only had a curtain across the doorway to their bedroom instead of a door with a lock, the provider has a master key to their group home staff that works on the front door of many of the group homes that they operate. And so staff might have a key to group homes that they don't typically work in, and they shouldn't have a key to other people's houses if they don't have a reason to be there. Participants aren't allowed to decorate their room or common areas of their home within reason. So we know, I mean, most of us have probably rented a home or an apartment in our lives, and we know that there's some things you can't do, like, you know, remodel. But there are some things you can do within reason, like hang pictures on the wall, and our participants should be able to do that too. If the furniture was arranged by the provider and participants aren't allowed to move things around, or staff go in and out of participant rooms or bathrooms when they're occupied without knocking or asking permission to enter. They're all examples that might be a violation of this piece of the final settings rule. Any questions about this piece?
I have a question, and it's kind of in between 6 and 7.
Okay.
So in the continuous habilitation walkthrough thing, I use the word thing because I don't know if you consider it a case note or service review. Number 15 of the actual onsite, it says, would their visitors be able to spend the night? Does that fall under the HCS or HCBS rule, or is that just a state-specific rule?
It sure does, and we'll get it into it in a couple more slides.
Okay, well, I was wrong. It wasn't 6 or 7.
No, it has its own standalone rule. Okay. So number 8, schedule control and access to food. So the setting provides options for individuals to control their own schedules, including access to food at any time. This is a big one that we see a lot of settings struggle with. So can the participant choose to eat their meal at a time and place of their choosing? If there's a menu, can the participant request an alternate meal? Are snacks available and accessible at all times? Is the participant able to eat alone or with whom they choose? Is it clear that the participant isn't required to adhere to a set schedule for meals, bathing, waking, and bedtime? And does the participant schedule vary from day to day or differ from others served in the same setting if that's their preference? So if we go into a setting and everybody has the same schedule, that is potentially a red flag. If the participant's schedule is exactly the same every single day, that could also potentially be a red flag. Now, some people prefer, and it breaks their brain a little bit if you ask them to deviate from their routine, and that's okay. But if that's not their preference, then that isn't what we should be seeing on a regular basis. There's a bunch of questions I'm going to come back to just to make sure that we get through everything. So examples of non-compliance with this is if the participant was discouraged from or not allowed to have a snack at 2 a.m. if they wanted to. If there are house rules about the use of TV or internet at certain hours. So house rules are things that pretty much all the adults in the house agree that they want to do. And so if the house rules are being made up by the provider or the SLP, because here's the thing about house rules is that everybody wants to have them. And so everybody just follows them. They don't have to be enforced on people. And so if they say, oh, this is our house rule that, you know, nobody has any screen time after 9 p.m. But in order for that to happen, they have to shut the Wi-Fi router off. That tells me that this isn't a house rule that every adult in the house agrees to. This is the house rule that is being enforced by some members of the house on other members of the house. And if it was a house rule that all the adults in the home agreed to, that wouldn't be necessary, right? We would all just stop using our screens at 9 p.m. We wouldn't have to turn the Wi-Fi off, right? Yeah. So, I mean, there's things that, you know, like with a lot of things, like things can be encouraged. But, you know, if I have a roommate and we kind of collectively agree that, you know, we're not going to throw loud house parties on weeknights, and that's our house rule, and we both agree to it. But I can't enforce that on my roommate. My roommate can't enforce it on me. Now I might decide if my roommate goes back on those agreements that we made between us, that it's not a good fit as a roommate, and I want to find a different place to live when our lease is up. But house rules are things that all the adults in the house agree to and don't have to be, and really can't be enforced on each other. That's not how a roommate situation would go with any of us, and that's not how it would go with our participants. And so if there's rules that are being enforced on a participant that they're not voluntarily, you know, agreeing to and going along with as a member of a household, then that's probably more in the area of a rights restriction. Access to the basement, that one would be a little bit different if it truly is his office, because there are some areas of a home that are not, like there are common shared areas, and then there are private spaces, like sometimes an office, sometimes bedrooms usually are that way. You know, my husband has a shop at our house that only he has a key to. I could if I wanted to, but I don't. But I mean, if I want access to it, I have to go through him. Like that's not an uncommon thing for people to have personal spaces outside of their bedroom in their home. But if it's like there's a family room down there and an entertainment center and whatever, and then there's also an office off to the side and they're limiting access and calling the whole basement their office, that seems like it would be more unreasonable because there is space down there that reasonably commonly would be considered shared or common space. So that one could depend. What about if there are rules that food is provided by the company and utilities are paid for? Not everyone likes the same food. The participants' room and board contributes to those things and should be used to purchase food that is consistent with their preferences. And they should always have alternatives available. They should always have options available. They should be part of the grocery shopping. And so if that's not happening, if they aren't offered alternatives, if they don't like what's on the menu, if they don't have a chance to contribute to what's on the menu, they don't have the opportunity to make sure that there are, you know, snacks and things available that are to their preferences, that could certainly be problematic in terms of this part of the final settings rule. So if, for example, the participant is expected to bathe every day in the morning and that's not their preference, that's would be an example of not allowing them to set their own schedule. If the participant can't eat in the living room in front of the TV on occasion if they want to, or, you know, that type of thing. If there's a rule that everybody has to eat at the table and eat at the same time, that's going to be problematic under this aspect of the final settings rule. And there's some other examples there. I'm going to come back to cameras. And that's actually something we're working on, maybe getting some guidance out from central office on, because there's a lot of nuances to that. I'm going to come back to that though, because I only have 20 minutes left, as Jillian is so kindly reminding me. So visitors, the setting provides individuals the freedom to have visitors at any time. So do day sites encourage visitors from the broader community and otherwise encourage interaction with members of the public? Are visitors allowed? Are visitors limited to specific hours? Are they limited to being with the participant in specific areas? Do visitors have to be approved ahead of time? Those are some exploratory questions to ask. And some examples of non-compliance could be if the participant's family or friend can't visit them for lunch at their day site, if a participant isn't allowed to invite a friend to visit them at their home, if a provider had a policy that overnight guests are prohibited, that would certainly be non-compliant with the final settings rule. If visitors were only allowed in the living room of a participant's home and weren't allowed to spend time in their bedroom with them or other areas. Visitors have to be approved by the provider and housemates teams before they visit. I've seen providers try to put that in a lease before. That is certainly not allowable under the final settings rule. And a participant is allowed to visit a friend at their home, but the friend can't come visit the group home. Because some providers will try to say, well, they can visit. They can spend time with this friend. We aren't limiting that. We just aren't letting it happen in the participant's own home. Still no. Still a violation of the final settings rule. So any questions about that? Does that answer your question, Kyle?
My question was just like with the overnight guest, is there a regulation on like time frame that they can say, no, this person's been here too long, because then they begin residency or occupancy or something like that, and then you have to go through the eviction process to ixnay them out from being squatters?
Residency is an interesting concept that I've actually gotten a lot of questions about. A lot of landlords will put limits on overnight guests and set a point at which that overnight guest would have to be on the lease. And that is super common, and that would not be something, if you saw it in a lease agreement, that would be out of line or unenforceable. But if there was nothing like that in there, then, you know, no, the provider doesn't really have a, you know,
Okay, that answered it.
from the perspective of a service provider, that's not really something that they could limit necessarily.
I think sometimes we tiptoe into an area like so to maybe the flip side of that. So like a shared living provider might invite someone into their home as a guest, and what the participants' rights are related to that. And that maybe gets more into our waiver stuff versus final settings rule, but there is really a gray area there too about their right to have some say in who's a visitor in their home. And I don't know if it plays into that. And if it doesn't, that's fine. And you can say that's a whole different topic and we can talk about it another time.
Sure. I mean, yeah, obviously the final settings rule doesn't go into providers' rights. But when you're choosing to share a home with another person, you are kind of accepting that, you know, You aren't going to have complete control over who comes in and out of the home. And you want to find a good fit for somebody that isn't going to invite visitors in a way that is not to your preference or that is particularly upsetting or disturbing for you. And if that's not happening, then just like any of us in a situation where we have a roommate that is a disaster that we're not a good fit with, we should be supporting them to look at, are there other options? Is this just not a good fit? It doesn't mean that either side is right or wrong. It just means that, you know, just like any of us have had roommates that we just said, this is a person I can't live with. Our participants, I mean, we should support them to navigate those situations just like we would if we were in them in our lives. Because at the end of the day, it's a roommate situation. It's a bit different for most of us, what most of us would encounter, because that roommate is also a service provider. But you know, those differences in preferences and things like that, they should look the same way. Somebody asked, participants use social media dating sites and invite strangers to their homes that present a safety risk. You know, if there are going to be limitations placed on a person's ability to have visitors, it would certainly be a rights restriction and a modification of the final settings rule, which, like I said, we'll get into here in a minute. And the last piece is physical accessibility. So the setting must be physically accessible. So either grab bars, ramps, and other accessibility items for those who need them. Are there viable exits in emergencies? Are appliances accessible to participants? Are tables and chairs at a convenient height and arranged so participants can use furniture comfortably? Is the setting free from obstructions that would limit participant mobility within the setting? And if obstructions are present, are there environmental adaptations like lifts, elevators, ramps, etc.? So if the bathrooms at a day site aren't large enough for a person who uses a wheelchair to be supported to use a bathroom or changed in, that could be a final settings rule issue. If the emergency exits are not accessible to those with mobility needs. This was an example I saw from another state. If a person with a wheelchair in a residential setting isn't, you know, if they don't try to make sure that they have a front loading washer and dryer instead of a top loading washer, it would be almost impossible for a person who relies on a wheelchair for mobility to use a top loading washer. You know, provide them with appliances to the best of their abilities that the participants can use as independently as possible. Could be an important thing to think about. Furniture is arranged in a way that makes it difficult for a person with a fall risk to navigate their environment. If there was maybe a step between two areas of the setting with no lift or ramp, basically making the areas on either side of that step inaccessible to somebody who uses a walker or uses a wheelchair. And one that I don't think about a lot because I don't know if we encounter it as much, but if lighting or visibility accommodations weren't made in the home of a participant with a vision impairment, those types of things can be accessibility issues also. Okay. So modifications, I mentioned it a couple of times. So in the federal regulation, they use the word modifications, and it allows for modifications of the requirements in the final settings rule. However, this is only allowed when the need for modification is supported by an assessed need and justified in the participant's plan. And the documentation of the modification must include those things, which you'll see a lot of those things dovetail with what we expect for rights restrictions. Because we have rules that say a restriction cannot be used in a way that would harm the participant. That's one of our requirements for a rights restriction. We have to discuss less intrusive methods that have been tried. We have to discuss positive interventions and supports, all of those types of things. So really, when we're talking about a modification of these requirements, we're talking about a rights restriction to some extent. And so that is allowable, but it must be just like a rights restriction based on an individual person's assessed need. That's why we can't do things like across the board rights restrictions or house rules. Any restriction used must be based on an individual person's need with the accompanying documentation. So if we're going to deviate from the final settings rule, if we are going to modify how we comply with it, it can't just be done as part of a rule in a lease or as a provider-wide rule at their day site. During the first session this month, somebody said, I have a day provider who says that nobody at the site is allowed to use their pocket money to buy snacks or drinks from the vending machine because not everybody has pocket money for that and somebody might get mad. That's a really great example of something that is a violation of the final settings rule and cannot be put in place as a provider-wide rule or a setting specific like house rule. So in your question, Angela, if there is a risk, if the participant is engaging in high risk behavior and does not understand all of the risks and cannot keep themselves safe, and the team decides that restricting their access to visitors that they meet on dating sites that they don't know and bringing them back to their house or inviting them to their house, if that's not safe, then that would be a modification. It would also be a rights restriction under division policy. And we would just have to make sure that we are doing that in a way that is compliant with all applicable policies. So how do state laws and policies intersect with the final settings rule? So as you can see, many of those things in the final settings rule are things that we would define as rights that our participants have, even under our state laws and regulations and policies. But there are some elements that are things that have traditionally not always been considered rights or across the board expectations, like leases and locks on bedroom doors. Because there are people who, you know, choose to live with a friend and may not have a formal lease and things like that. And so those are things that are not typically considered like a right that we expect to see in every single situation. But by federal regulation, they have laid out that these are rights that we are saying people have that must be observed when they are in HCBS services and when they are served in a provider controlled setting. So people don't just have a right to not be segregated from their communities or restricted from public spaces, but we have a responsibility and an expectation via the final settings rule to actively support their full integration. So, you know, as far as just straight legal rights go, we would say that you don't have the right to limit a person's access to their community, but for our participants and in these settings, the final settings rule takes it a step further and says, not only does this person have the right to not be limited from these things, segregated from their community, they have a right to be actively supported to be a meaningful part of their communities. And we have that expectation for our service providers when participants are served in these settings. So this kind of builds on and adds to a bit what we would say are the basic bare minimum fundamental rights that we all have. And as I mentioned, when we're going to modify some of these things, the elements of the documentation also intersects closely with our policies around what needs to be documented for rights restrictions. So this is another reason, in addition to our, our policies around it and our performance measures about it, but this is another reason why thorough documentation of rights restrictions put in place by the team is so important, especially when it's around access to food, community access, visitors, and relationships, because not only are those things required by our regulations, modifications of the final settings rule that don't have the appropriate documentation in the person's plan could also be a violation of the final settings rule. Another thing the federal regulation does is it ties compliance to the site where the services are delivered, not necessarily just the services. And so these sites are owned, leased, operated, or controlled by waiver providers. And so the agency providers are responsible for what happens in these settings and the compliance of those settings. And that is even when that setting is also a private home, like an SLP's home or sometimes a family member of the participant's home. And that's something that can be hard for some people to think about, because they're like, well, of course I can shut off my internet router at 9 p.m. This is my house. Yes, it is your house, but because you're choosing to have a participant living there with you and to get paid Medicaid dollars to provide this home and community-based service, your setting isn't just your private home. It is also a Medicaid services setting, like a hospital, like a, not the same, but you know what I mean? Like, there are rules around that that are different from when it's just your private home. And it is our provider's responsibility to ensure they're responsible for what takes place in that setting, because they are operating it, even if it is someone's private, their contractor's private home. And so they have a greater responsibility there. So what do we do? I know I'm running short on time. What do we do? So the responsibility for monitoring compliance with the final settings rule is everyone's responsibility in a general sense. So when you notice possible non-compliance with the final settings rule in your service reviews, your ISP reviews, your T-log reviews, and things like that, you can raise those concerns with participant teams and providers. Sometimes the federal regulation can be another tool that we use to help teams understand what is and isn't allowed in Medicaid services. So sometimes, rights can be kind of nebulous to understand, and restrictions can be kind of hard for folks who aren't in our industry to understand. But if there is a piece of the final settings rule that directly applies to maybe a concerning or problematic restriction a team wants to put in place, adding that final settings rule information to the mix and saying, not only is this not allowable under our division policies, there is federal regulation that governs our services in settings like this that says the participant must have access to food at any time, and that can only be modified under these circumstances. And so because that isn't the case here, not only is this not allowed under our state policies, it is not allowed under federal Medicaid regulation as well. So it's just an additional thing that can help families understand that it isn't just you at the table saying no to what they want, or the state. It is a federal expectation that governs all of our waiver programs. So what do we do when we notice an issue? So we have folks on our QI team who specialize in monitoring for compliance with the final settings rule. There might be times that you aren't sure if what you've observed is non-compliant with the final settings rule. And there may also be times where you've brought an area of non-compliance to a provider's attention, and they've disagreed or agreed to disagree, Tammy Badisher, or not taken the action needed to resolve the issue on an ongoing basis. And when that happens, those situations can be escalated through your supervisor, through your SDAs, to the QI team, and we can send people on site or do records reviews and make a determination on final settings rule compliance. And when we do that, we have pathways, processes, letters we use where we can then send a letter out to the provider saying this setting is not compliant and you have X amount of days to resolve this, and let us know how you're doing that. Or, we can't continue to fund services here. And so we can kind of put the responsibility back on the provider, because like I said, they're ultimately responsible for what takes place in these settings. So just one more tool in your tool belt, and one more way that we're kind of here to support you guys to navigate things like this. So I'll come back and answer questions for the last 3 minutes, but I just want to, here's the resources. Here's the link to the federal regulation. Here's a link to our final settings rule webpage. It has a cool poster illustration that lays out the final settings rule that you can share with folks. It has our state transition plan. It's a super boring read, but it's there if anybody's interested. There are also some recorded CQL trainings on the final settings rule that are really great that you can, take advantage of yourself or share with providers, with families who maybe don't understand it. And all of our assessment tools that the QI team uses to assess compliance with the final settings rule are out there as well. I also have linked the federal CMS final settings rule compliance toolkit, there's technical guidance there that CMS has offered. And that's where there's 2 documents with exploratory questions, one's for residential and one's for non-residential settings, if you want to know more about those. And there are questions, exploratory questions they gave that I didn't feature because PowerPoint slides have a limited amount of space. So lots of good resources. And then the last one is the landlord tenant handbook developed by Legal Aid of Nebraska. So if you have a concern about how your participants being treated in like the landlord tenant relationship with their provider, that's something you can share with them and their guardian to make sure that they know what their rights are and that they know what resources are available to protect their rights. So going back to questions, so on cameras, I will just say that this is something the division is looking at because we've kind of, our understanding of this has shifted over time. And so we're working on getting some maybe more helpful guidance out, not just for you guys, but for providers as well. So that because right now we've kind of been managing these situations on a one-off basis as they come up, and that's not always working out the best. So more to come on that piece. Kyle, I'd like to discuss that separately because I have questions. I have questions and would need to get more in the weeds before I could say with any level of confidence what guidance I might want to give in that situation.
And that's what Jillian said, so we're good.
Yeah. Let's see. I think I answered most of the questions as we went along, Jillian. Were there any that I missed?
I don't think so. Did you answer the social media one from Angela? I think maybe you did. Okay. Yeah, I think so. I think we're good.
Okay. Was there anybody else? Sorry, we ran a little bit short on time, but great questions and discussion today. I really appreciate everybody taking the time to tune in, asking great questions and the good discussion, because this is, I don't know, the best way I think for everybody to learn. If you are going back to your work and marinating on this and you're like, oh shoot, I have more questions about what it looks like for this situation that I'm encountering or what have you, your SCSs and SDAs are great resources, but I'm always happy to help as Wanda, my counterpart here in QI, and her team, who are kind of those that also specialize in final settings rule stuff. So we're always here to help if you have questions or want more information or guidance in these situations. So everybody have a wonderful rest of your day. Happy Halloween, and we'll see you next month.
Thanks, Sarah. Thanks, everyone. Take care.